Good morning. Hello and welcome. If you are a student curious about how privacy laws are shaping the digital economy, or a professional navigating compliance in your industry, or a business leader responsible for safeguarding user data, this series is for you. In this video, we'll explore India's landmark Digital Personal Data Protection Act 2023, a transformative law that defines how personal data are collected, stored, used and protected in digital era. But we are not just scratching the surface. This is a deep dive across 8 focus parts where we break down the impact of the DPDP Act on some of India's most data driven and compliance sensitive industry, namely the BFSI sector, where consent, risk, and reporting rules are redefining how banks and insurers operate. We'll look at the IT service industry where global delivery centers must align with both Indian laws and clients' expectation. Then we look at the healthcare sector where patients' rights and sensitive data demands ironclad protection. We'll then move to the hospitality industry, wherein managing trust, identity, and personal preferences of millions of guests are involved. Then we'll go to the education sector, where children data is at the center of privacy enforcement. The world of marketing and sales, where consent is now the backbone of every outreach strategy, will be looked at. And finally, the social media industry, navigating new restrictions around profiling, tracking, and child safety. So, whether you are preparing for compliance in your organization or simply want to stay informed, this series is designed to simplify the law, contextualize the impact, and guide you through practical next steps. So, grab a cup of tea, stay tuned, let's decode the DPDP Act together, one sector at a time. This is your host, Savit Vittal Salian. Namaskar and welcome. Digital Personal Data Protection Act, Part 1. This is the agenda for the Part 1. We'll be going with the introduction, its legislative journey, applicability and scope, key stakeholders and definitions, core principles and rights, legal ground for data processing, consent based processing, legitimate use, special provisions for children, duties of data fiduciaries, breach notifications and enforcement, Data Protection Board of India, penalties and offences, cross border transfers, sectoral overlaps and ambiguities, compliance roadmap, and then we'll close with a conclusion. Do note this is the base part. As we move to the next parts, which would be very sector specific, the recommendation is go through the base and then go to the sectors, because certain areas would be unique in individual parts, but majorly part 1 would be the foundation on which the sectors would be built on. I hope this helps with the context. The rapid digitization of India over the past decade has transformed it into one of the world's largest data generating nations. With smartphones in every pocket and services increasingly shifting online, The call for a robust data privacy law has been long outstanding. The landmark 2017 Supreme Court judgment in Justice case Puttaswamy versus Union of India recognized privacy as a fundamental right, setting the legislative gears in motion. Fast forward to August 2023, and India enacted the Digital Personal Data Protection Act 2023, a significant milestone ushering the country into the global privacy governance arena. Let's look at the legislative journey. The journey of DPDP Act was marked by extensive consultation, multiple drafts and stakeholder debates. If you look at the journey starting off with 2018, Justice Sri Krishna Committee proposed the first draft. Between 2019 and 2021, several iterations reviewed by the Joint Parliamentary Committee were done. In 2022, MEIT introduced a simplified draft for public consultation. In 2023, Parliament passed the Act in August 2023. As of early 2025, as we speak, the Act is not yet fully in force. It's pending notifications of detailed rules and formal establishment of the Data Protection Board of India. Let's look at the applicability and scope. The DPDP Act governs the processing of digital personal data within India and extends its jurisdiction to processing outside India if it involves offering goods or services to individuals within the country. However, it does not apply to personal or domestic use or publicly available personal data. In simple language, if you put up from an applicability and scope perspective, the DPDP Act applies to digital personal data. That means any data about you that's stored or processed using computers, smartphones, or the internet. Now, who and what it covers? Well, any personal data collected in digital form, whether directly, online, or offline, and then digitized. It applies inside India and also outside India if a company or a platform is offering goods or services to people in India. For example, a US based app is collecting data from Indian users will be covered. Now, who and what it does not cover? Well, personal or domestic use. That is, if you are storing your friend's birthday or keeping a contact list, that's private. And this law doesn't apply in such cases. Second is data is made publicly available for you. That is, if you already shared your data publicly, like in social media, etc., it is generally not covered as part of this act. In summary, if someone is using your digital personal data in a business or professional setting in India or targeting India users, the DPDP Act steps in to regulate and protect your privacy. Now let's look at key stakeholder and definitions. Data principle. The individual, it's an individual to whom the data belongs. So in your case, your data, you are the principal. Next is data fiduciary. is the entity determining the purpose and the meaning of processing. Data processor, which is processes data on behalf of the fiduciary. Next, significant data fiduciary, which is entities handling very large volume of sensitive data or could impact national interest are known as significant data fiduciaries. Next is consent manager. It's a registered intermediary managing user account. Now let's go into details of it. Let's try to understand in simple language. Data principal, who? It's you. You are the data principal for your data. Is the individual whose personal data has been collected or used. So do remember the word data principal for your data is you. You are the data principal. Example, if you sign up for a shopping app, you are the data principal. Next, data fiduciary. Who is this data fiduciary? Well, the organization or company that decides why and how your data will be used. Example, the shopping app company that collected your name and number and address. Now, if you go to a shopping mall and if there are organizations which are collecting information to provide you with a gift or a surprise gift or something which could entice you to provide your information. So in that case, you are the principal and the organization or the business that is collecting becomes the data fiduciary. Data product processor. Who are these? Well, it's a third party that processes your data on behalf of the data fiduciary. So the guy or the person who collected your information in the shopping mall as an example is a data fiduciary, but that guy would not do anything with that. He would send it to someone to collect, collate and decide where this has to be given or what it has to be used for. So that's the party which is a data processor. Example, a cloud service provider hired to store customer data as an example. Next is the significant data fiduciary. Who is this? A big or high risk data fiduciary, either because they handle tons of data or lots of data, sensitive data, or pose risk to democracy, public order, etc. They have an extra responsibility like hiring data protection officer and doing a regular audit. Now, who are generally these significant data fiduciaries? Well, look at your online presence. You have various apps, social media tools. They collect data in tons, or rather anything and everything that is possible, they would collect it. These are significant data fiduciaries. Yes, the Facebooks, the Googles, or the apps that you use for your procurement, groceries, Amazon, and so on and so forth. These are generally termed as significant data fiduciaries. We have classic cases of these data being misused, hence causing a risk, a potential very high risk. Similarly, the apps on your phone, look at your phone, look at the apps that you have, the amount of information that you have shared knowingly and mostly unknowingly. So these are categorized as significant data fiduciaries. Next is consent manager. Now, who is this consent manager? It's a neutral platform or service that helps you manage your account. That is, what you agree to share and with whom. Think of it as a privacy control panel you can access anytime. In simple terms, data principal is you, the individual. Example, a person using a mobile app. Data fiduciary is the one collecting or using your data, the mobile app company, etc. Data processor, the one helping with the data work, a data storage service example. Significant data fiduciaries, big high risk data handlers, a social media giant, or banks. Consent manager could be a tool to manage your permissions. Example, app to view or revoke your consent. I hope this helps clarify these 5 terms. You can revisit this slide later on when you have questions or you want to refresh it. But this becomes your foundation. Let's now look at the core principles and rights. The Act rests on the principle like purpose limitation, data minimization, accuracy, storage limitation, and security safeguards. So, what are the rights of data principle? They include right to access, right to correction and erasure. Do remember, you are the principal. So you have the right to access. You have the right to correct and erase if required to. You have a right to grievance redressal. You have a right to nominate a representative in case of a death or incapacity. Notably, these rights primarily apply where consent is the basis for processing. Well, in simple language, if you want to put it up, these are the guiding rules that every organization must follow while handling personal data. Let's revisit. What's purpose limitation? Well, it means collect only the data needed for a specific reason and use it only for that purpose. Now think through. What purpose did you provide the information, your own information, if you remember it? Now think through, is it been really been used for that purpose and only that purpose? You have a question mark. This is where the Act defines it clearly. If something is collected for a specific reason, it should only be used and for that purpose only and no other. If not, you are breaching the purpose limitation aspect of the Act. Next, data minimization. It states, don't ask for more information than what is necessary. So anyone who is collecting information are required to inform you or provide you with visibility on why they need it. And for that purpose, only that specific aspect should be collected, nothing beyond it. So don't ask for more information than necessary is data minimization, keeping it at minimum. Next aspect is make sure the data collected is correct and up to date. Look at the name. Is the name correct? Are the details associated with you accurate? It's the core principle that this accuracy is to be maintained. And you have a right to see what is there. And you have the right to correct it if the accuracies are not there or information is incorrect. Next is storage limitation. Now what's this? Well, don't keep personal data longer than needed. Delete it when the job is done. Now, do you really know how this is done? They have collected it, but when they collect it, do they inform you till what time it would be kept? What is the duration of that information? What would be the life of that duration of that information that they are keeping? When did it get deleted? Generally, the answer is no, or we assume it. Example, if a bank has collected an information when you opened up an account, it should delete all that once the account is closed. But are you sure that it is done? As per this law, this would be ensured. The law would take its course if there is a deviation. That's the expectation from this law. And that is an expectation this law would set, example, to the bank. We'll come to that when we go into the specific area, but that's the spirit of the limitation. Delete it when the job is done. Next is security safeguards. Keep the data safe using technology and policies to prevent leaks or unauthorized access. The DPDP Act would bound the businesses to ensure that there are no leakages, or the organizations have put up enough controls in place so as to ensure your data is not leaked or there is no unauthorized access. This act, once enforced, would mandate every organization to ensure they would be liable for it. Next is accountability. The data fiduciary is responsible for protecting your data. Do you remember who the fiduciary is? The person who, the organization which collected the information. They are responsible for protecting your information, for your data. Even when they share it with someone else, like a data processor. So assuming you filled up a form in a mall or in a raffle, and that information is provided to some other organization for consolidation or sales, and there is a breach, the organization which collected, which is the data fiduciary, would be held responsible once the act is in play. Only thing that you have to remember is whom you have provided, so it can be easily, if you find that there is a leakage. The organization which collects this information, the guys and people who are there in the mall behind you asking for your information, can you fill up this small form? You would be entitled for a gift or a raffle or an award. Today, they are not having any laws which can make them accountable. The moment this act comes into play, even they become accountable and they would be serious liabilities in case of breaches. That's the expectation from this act. Now, if you are an organization which are involved in this, of collecting information, if you are a banking, financial institution, sales organization, an insurance company, which are involved in asking for information left, right, and center, multiple information, or you are involved in collecting information unknowingly from a user, this act would bind you to the requirement, would make you accountable for it, and penalize you if it is misused. That's why this act is a game changer. Now let's look at the rights of the principal, or the data principal. Well, the act gives individual more control over their data. These are your digital rights. Now, what are those? Right to access. That is, you can ask what data is being collected, why, and who it's shared with. Today, do you even ask for it? So when you get this request next time, you have the right to ask what has been collected, why is it been collected, and after collection where it would be given. While the carrot is that you would get a gift or something like that, but is it the only recipient? How are you making sure, or how are they making sure that it is not being used for anything other than what is intended for, or at least what has been declared? Difficult question to answer. But then you have every right to ask. That's the right that you get because this act, once it gets into play, gives you that authority. Next is right to correction and erasure. You can ask to fix wrong data or delete it if it's no longer needed. You have the right to ask for deletion if no longer needed. You can give that instruction. Next is right to grievance redressal. That is, if something goes wrong, you have the right to complain and get a response. Next is right to nominate. You can name someone to act on your behalf if you are unable to, if there is a misuse, or if you need some changes as such. In short, the DPDP Act is designed to ensure that your data stays yours and that anyone who uses it does so transparently, responsibly, and securely. I hope this helps you with certain perspective. Legal grounds for data processing. Data can be processed with consent and under legitimate use. What's with consent? With consent is must be free, specific, informed, and unambiguous. Under legitimate use means such as emergencies, legal obligation, employment, public interest, or government functions. Let's try to understand in a simpler way. Under DPDP Act, your personal data can only be used if there is a valid reason. These valid reasons are called legal grounds. There are two main areas here. First is consent based processing, wherein your permission matters. Before collecting your personal data, an organization must ask you clearly, and you have the right to say yes or no. So, what makes consent valid? Well, first, you have clearly agreed and it is free, there is no force or pressure on you. It is specific, that is for a particular purpose, and it's informed. You know what you are agreeing to. Do note, clearly agree, it's free, specific, and informed. This is what makes consent valid. You can also withdraw consent anytime, and the organization must stop using your data there and then. Now let's look at legitimate use. What is it? Well, in some situations, the law allows your data to be used without your consent, but only for a valid and limited purpose. Now, what are these valid and limited purpose? Example, voluntarily shared data. That is, if you have already made the data public, or government services like subsidies, or you are getting a subsidy, or going for licenses or certificates. In case of medical emergency, that's also a valid purpose, that is to save your life or someone else, or law enforcement, or there is a court order, or there is distress or disaster, or there is a risk to the public health like during pandemic, or for employment purpose such as payroll or workplace safety, or there is a legal obligation which is to complying with India laws or judgment. In these cases, there is no consent needed and it's considered as a legitimate use. But do note, it has to be strictly within these 7 areas at this point of time. So, check out which part is a potential that is already in play from your perspective. Now, let's understand from a simple analogy perspective. Think of your data like a locked box. If someone wants to open it, they usually need your key, which is your consent. But in emergency or under strict legal order, the box can be opened without asking, but only for your benefit or for public safety. I hope this gives you a little better perspective on what we are looking at in this space. Now let's look at a critical aspect on special provisions for children. Well, children here in this act are defined as those under 18. It is a fiduciary must. It's a must. In case of an underage or under 18 children, they need any collection, any processing would require parental consent. They cannot, the fiduciaries cannot monitor or target audience or target advertisement towards this category. They are supposed to avoid any behavioral monitoring. Yes, they may receive exemptions if processing is verifiably safe. But that would depend on the government notification. We'll wait for it when it comes in. But children under 18, they have a very stringent and clear guidelines at this point of time. Parental consent is the first and the foremost. Let's try to understand it much more clearly or in a simple language. The DPDP Act treats children's personal data with extra care because kids may not fully understand how their data has been used. Now, as per the Act, who is considered a child? As mentioned, anyone under the age of 18 is considered a child under this law. This is stricter than many global laws like GDPR, where the age is 13 to 16. But in India, it is very clear anyone below 18 is a child. So, what must companies do when handling children's data? The first and foremost is get parental or guardian consent. Companies must take verifiable permission. Important, verifiable permission from a parent or legal guardian before collecting a child's data. Now, do remember this specifically. It's the ownership of the company as to how they will verify, how they will ensure that the consent is provided by the parent or the guardian. The ownership is on the organization, that the information that they have collected, and if it is from a child with below the age of 18, it has been collected with the consent of the parent. It is the ownership of the company to prove it. So when companies handle children's data, no tracking or profilings are allowed. Companies cannot monitor a child's online activity or create digital profile based on their behavior. Companies, when handling children data, cannot target any advertisement towards the kids, to the child. Ads meant specifically to influence children based on their interest or habits are strictly banned. Now think through, how many advertisements do you see today online which caters to children? And check out whether your own child is watching it. If so, how was that consent taken? Was there even consent taken? The answer generally would be no. This act tries to address that. The companies would be held accountable if such a thing has been observed, and the companies would be asked to prove the consent was taken and how they verified the consent was provided by the parent or the right guardian, by the right guardian and the right parents. How have they ensured? The ownership is on the organization. There are possible exemptions. The government may allow some exceptions if the platform can prove it is safe for children or the data processing is in the child's best interest. Yeah, these are the two conditions at this point of time. These exemptions will be notified officially and must meet strict safety standard. So let's wait for the refinement of it. But at this point of time, these are the two conditions in which exemptions could be provided. But to prove it is safe to children and it is in the best in child's interest, the ownership lies on the company. Now, why this matter? Well, children are vulnerable online. These rules ensure that apps, websites, and digital services don't exploit or misuse their personal data. In simple terms, if a company wants to collect data from children, they need a parent's yes, not just the child tapping on agree button. And they can track or target them with ads like they do with adults. But then, two conditions: parents' approval, guardians' approval, and company need to ensure it is really from them. How they do it is a challenge for a company to figure out. So, what are the duties of the fiduciaries? First, provide clear notice. Second, implement security safeguards. Third, report any breaches. Fourth, erase data after the purpose is served. Last, ensure processors also comply. What are significant data fiduciaries must or additional responsibility? Well, significant data fiduciaries must appoint data processing officer or DPOs in India. They would need to conduct data protection impact assessment. They need to undergo periodic audit and they need to appoint an independent auditor. Think through the liabilities or the expectation this act has on entities in India dealing with Indian population and Indian data, and organizations outside India but processing data from India or Indian citizenry. So, all of these are required as part of the act. In simple language, a data fiduciary is any company or a website or an app or organizations that collect and decides how to use your personal data. The DPDP Act lays down strict rules they must follow. So, from a responsibility perspective, the key responsibilities for every data fiduciaries would be: first, be transparent, which is give proper notice. Before collecting your data, the data fiduciaries must tell you what data they are collecting, why they are collecting it, how they'll use it, how you can withdraw consent or raise a complaint. That's the first part. That's been transparent. Second is taking your consent honestly. They must get your clear and informed consent. No hidden terms, confusing language, or forced agreement. It has to be clear and informed. Now, this is where the trick lies. Currently, most of us would select yes because reading the whole thing, it's a nightmare. This act defines it now, that how it should be or what it cannot be. That empowers you as a user. The citizens of this country gets this authority as part of this act. The third is keeping your data safe. This is the responsibility of the data fiduciary, is to keep your data safe. They must use security measures like encryption, access control, and monitoring to protect your data from leaks or hacks. So the fiduciary is now accountable. There are no leaks or hacks on the data that they have collected from you using your consent for that specific purpose. For that, the fiduciary needs to ensure every possible, which includes encryption, access control, monitoring, but not limiting to that. Anything and everything to avoid a leak or a hack on your data needs to be done by the fiduciary. The Act mandates it now. The other key responsibilities of data fiduciary is to reporting data breaches. Now, if after doing all of the above there is a breach, the fiduciary needs to inform you and the Data Protection Board. Think about it. Today, if there is a breach, you will not even know about it unless it is in the news. With this act in play, the fiduciaries are made accountable to inform you individually if you have been impacted. So that's the power of this act, being a power that has been given to every individual of this country. The other key responsibility of data fiduciary is to erase data when it's no longer needed. That is, once the purpose is over, or if you withdraw consent, they must delete your data and also ensure any third party processor does the same. So, this is a major challenge for those organizations which are collecting your data and sharing it with multiple processors. If you have ensured that the authority has been given to the first one and tomorrow you want to revoke it, the fiduciary or the organization which collected the information are liable to ensure that the organization they have shared in the back end also are informed, and if there is a breach there, they are held accountable for it. So if an organization is good at collecting data and sharing it with for monetary purpose or any other purpose, and if you have withdrawn it from the primary, the organization's responsibility is to revoke all that he has shared with or they have shared with any other organization they have in the back end. The next is erase data when it is no longer needed. We discussed this. Deleting your data, and the next is ensuring processor follows the law too. Now, if they use another company to handle your data, the fiduciary is still responsible for any mistake or misuse. Now, what's this? If someone has collected your data, your information, but has shared with other organization and there is a breach in the other organization, the primary would still be held accountable for that breach. Today, it's a black hole. Someone collects it and hundreds of other users uses it. If there is a breach in one, it's an open-ended stream. With this law in play, the team, the organization which collects the information are held accountable. They are responsible for the mistake or misuse of your data, even if they had not done it, but they had given it to an organization which did not follow all the requirements of the law. So, you or the organization which collecting data becomes directly accountable for it. So, organization, if you are one of those, if you're listening to this video or going through this, think through the liabilities that you would be entitled to for not being careful with the data that you have collected. special duties of significant data fiduciaries or SDFs. If the organization handles a large amount of data or pose high risk, they are called SDFs or significant data fiduciaries. And they must do more. Like they need to appoint a data protection officers in India. They need to conduct data protection impact assessment. They need to get independent audits done regularly, and they need to show higher accountability for compliance. So in simple words, if someone collects your personal data, they have a duty to protect it, explain it, and respect your choice. And if they are big or powerful, they must go that extra mile. Let's look at breach notification and enforcement. Well, while there is no fixed timeline in the Act at this point of time, but the draft rule proposes 72-hour notification. The fiduciaries must inform both the board and the affected individuals. Now, what's the Data Protection Board of India? Well, it's a quasi judicial authority with power to conduct inquiry, impose penalties, facilitate dispute resolution, accept voluntary undertakings, or appeals against board direction decisions which can go to the TDSAT, not to the civil court. Now, in simple terms, the Data Protection Board of India is the official body created to enforce the DPDP Act. Think of it as a privacy watchdog that makes sure companies and organizations follow the law. So, what does the board do? Well, they investigate complaints. If you feel your data rights were violated, you can file a complaint. The board will look into that matter. That's the first, that is investigating the complaints. Second, handle data breach. That is, when a company leaks or mishandles the data, the board can launch an inquiry, asks for an explanation, and decide what action to take. The third is imposing penalties. If an organization breaks the rule, the board can fine them, and the fine can be up to 250 crore rupees in case of serious offense or cases or breaches. The board also is there to resolve any dispute. The board can help resolve issues between users and companies through mediation or through a formal decision. The board accepts voluntary undertaking. They have been empowered to. That is, if a company admits its mistake and offers to fix it, the board can accept a settlement plan instead of imposing a penalty. That's an authority that the board has been provided by the Act. Let's now look at the structure of the board. Well, this board is appointed by the central government. It's led by a chairperson and another member. It is designed to be digital by design body. That is tech enabled, paperless and efficient. Now, where do you go if you disagree with the board? Well, if you disagree with the board, you can appeal to the Telecom Dispute Settlement and Appellate Tribunal, that is TDSAT. If you are still not satisfied, you can go to the Supreme Court with your grievances. So the first is, if you look at think through the flow, the act provides rights to the individual, that's you. To the organization, there is a responsibility. To the sub organization, the rules that they have to follow, the guidelines, to oversee that things are in order and followed as per the principle. You have the board. The board has its authority, it has the right to provide give penalties, impose penalties, it has a right to accept settlements, it is a central government appointed body, it is tech enabled. After all of this, if you are not satisfied, you can go to the Telecom Dispute Settlement and Appellate Tribunal. If you are still not satisfied with the outcome, you can go to the Supreme Court. So that's how the flow works at this point of time, till what we have understood at this point of time. In simple word, the board is like a data privacy referee, keeping things fair, resolving issues, and punishing bad behavior with big fines when needed. So now let's look at what are the penalties and offenses. Well, if the violation it's breach of children's data rules, the maximum penalty that can be imposed is 200 crore rupees. If there is a breach in the notification failure, that is again 200 crores rupees. General fiduciary non-compliance, it can go up to 250 crores. Now, if there is a misuse or frivolous complaints by an individual, the individual can be fined up to 10,000 rupees. So it's balanced, it's extreme in case of violation, which is enough to deter any organization from breaching. It has enough deterrence with it and enough teeth to bite. Let's now look at the penalties and offenses or in detail, or try to understand, simplify it. The DPDP Act doesn't just talk about rules. It also lays out strict penalties for those who break them. The goal is to make organizations take data protection seriously. Now, who can be penalized? It could be the companies, data fiduciaries, government bodies, significant data fiduciaries, and even individuals in rare cases for either misuse or false complaint. What are the major offenses and their penalties? Well, if you're not protecting the children's data, 200 crores, not reporting a breach, 200 crore rupees again, general non-compliance with DPDP Act, 250 crores rupees at max. Like we discussed, 10,000 rupees for false complaint or misuse. Note, these are maximum penalties. The actual fine will depend on how serious the offence is and whether it is a repeat offence. So there is a reasonable justification or a reasonable space being provided. But it depends on the board's decision. That's the teeth that has been given. Now, who decides the penalty? Yes, the Data Protection Board of India reviews the fact, holds an inquiry, and then decide whether there was a violation, how severe the violation was, and relatedly how much fine to be imposed. Now, what does the law consider before imposing a fine? The board will look at the nature and impact of the breach. Second, whether it was intentional or accidental. They will also look at whether it is first time or it is a repeat offense. They would also look at whether the company tried to fix the issue quickly or they have been negligent all along. All of these makes a big impact on what is the penalty that the board decides as fit for case to case basis. That is, if you misuse or neglect people's personal data, you pay the price. The fines are big enough to make even large company take notice. Let's now look at cross-border transfer. What are those? Well, unlike GDPR whitelist approach, India will maintain a blacklist of countries where transfers are restricted. Transfer to other countries are allowed unless expressly prohibited. There would be a blacklist of countries. If your data is being transferred to a list of a country and of the 10 there are 2 which are listed in the blacklist, you cannot do it. Hence, India's approach towards this is blacklisting rather than whitelisting. In simple language, cross border transfer is when your personal data is shared or stored outside India. It is called as cross border transfer. The GDP Act allows this, but with a safety net. What does the law allow? Well, under the DPDP Act, companies can transfer your data to other countries by default unless the Indian government says no. So you can transfer your data to other countries by default. What does the law restrict? Well, the government will publish a list of countries where data transfers are not allowed. This is called as blacklist approach. Unlike GDPR where it uses the whitelist method. So that is opposite of what India approaches. Two different ways of approaching similar challenges or guidelines. Now, why does this matter? Well, this ensures that your data isn't sent to risky or hostile countries. India retains control over how and where citizens' data flow globally. Example, if an Indian app wants to store your data in Canada or Singapore, it's allowed. Unless those countries appear in a unless those countries appear in India's prohibited list. But if app wants to send data to a blacklisted country, it can't, no matter what. In simple words, the government decides whether your data can safely go outside India or not. Most countries are okay unless officially marked as no safe for Indian citizen data. I hope this gives you a better perspective on the restriction that this act has. Let's now look at sectoral overlaps and ambiguity. There are overlaps. There are overlaps with RBI, SBI, IRDIA, AI, and certain. They have sector specific privacy mandates, and this act overlaps with that. Are there gaps? Yes, there are. There are no timelines for responding to data principals request. That means you can request, but by what time the other party can respond back, that clarity or clear definition is currently not in play. There is ambiguity in public data reuse, which we expect to come out clearly when the act goes through its revision before it gets into full flow mode. It lacks clarity on what children's data harm definition would be. What is defined as harming a child? Or what is that harm that data can cause would be considered as a harm to a children's related information. There is no explicit record keeping obligation at this point of time. So while DPDP Act is in India is new, centralized data privacy law, there are some confusion still existing because other regulators also have data rules. This can create overlap and gray areas. So while this DPDP Act is new, there are other laws in India. So, and they have to follow those also. So there would be an overlap to start off with. But as we know, it starts wherein multiple laws would be addressed the specific area. But eventually, when streamlining occurs, this should get addressed. These are initial teething issues, maybe. So, a same breach might be triggering of multiple actions from different laws. At this point of time, yes, possible. We're expecting this to be sorted out sooner than later. Let's now look at overlaps and ambiguities in detail. Well, several industries already follow their own data protection rules. For example, RBI. RBI has strict data storage and localization rules for financial data. IRDAI, which is insurance arm, it requires protection of customer health and policy data. The SEBI, which is the stock market regulator, covers trading and investor privacy. The CERTIN, which addresses the cyber security aspect, it mandates reporting of security incident within hours. So, at this point of time, you would also be governed with all of these rules when you are doing business in India. The DPDP Act is an add-on, of course, with a very specific agenda. But then at this point of time, it would be a addition, sometime overlap. The challenge? Well, these existing rules may conflict or duplicate with DPDP Act, requires causing confusion for companies. See, if it is a duplicate, should not be a challenge. It is just fitting your action against all of the duplicates. But if there is a conflict, is where the challenge will arise. While you might be following certain rules which is in compliance with whether RBI, IRDA, SEBI or certain, but it might be in conflict with DPD, that's a thing which the board would address before going live completely. So duplicate might be taken care of maybe easily or can be considered as not a big challenge, but a conflict is a challenge. That need to be looked at, and I'm sure this has been looked as we speak. Let's look at the ambiguity in DPDP Act. Here are some areas where clarity is still missing and rules are awaited. There are no timelines for responding to the user request. That's the first one. Now, the Act allows you to access, correct, or delete your data, but doesn't say how fast the company must respond at this point of time. Maybe it's a low hanging fruit, but every company depends on the automation and the processes that they have. They might take different times. What's the upper limit? What's the maximum that a user has to wait? That's currently not defined at this point of time. Maybe that will come out. Second is about publicly available data. That is, if our data is already public, that's on social media, can companies still use it for profiling or ad? The Act is silent on whether this is legal or not. Children's data. Detrimental effect not defined. What is it? Companies are banned from causing harm to children, but the law doesn't define what harm means. Is it emotional, psychological, or data misuse? That's currently not clear or not been defined actually. It just means harm, but what is the definition of a harm? What is specific? Or what are the examples? Next is the no record keeping requirement. Now what is this? The Act doesn't mention whether companies need to keep record of data flows or processing activity. Now, this is clear in GDPR. That's a big difference here. The record keeping aspect is not yet covered in DPDP. GDPR has clear requirements there. In simple terms, the DPDP Act is a big step forward. While it is a big step forward for the country, but we still need the fine prints to understand how it works with other laws and what exactly companies must do in trick situations. Compliance roadmap. From now for next 6 months or so, the action should be assessment, data discovery, consent mapping. That's the action you can take at this point of time. Post that, the next 6 to 12 months, you need to update your policies, DPIAs, and consent mechanism. You have to work on those. First, you do assessment, figure out how you are getting your information, the data, how you are discovering your user inputs. What do you do when you get that? How do you get it? Define your policies. Post that, deployment, onboarding, recruitment of DPOs, designing your audits, and continuous improvement. That should be your approach. Let's go into deeper. What does it mean? Well, the DPDP Act introduces new responsibilities for any organizations handling personal data. But you don't have to do everything at once. Industry experts recommend a step-by-step approach, like a roadmap. So here's what the journey typically should look like. Phase 1, get ready, which is assess your current data practices. What data do you collect? Why are you collecting it? And where is it stored? Get your inventory right. Answer these 3 questions. That starts today. Second, you find all the personal data across your systems. Look at your emails, your databases, your apps, and even your spreadsheets. Identify vendors or third parties. Who else has access to your user data? When you collected the data, did you collect it yourself or you got it from someone else? Or after you collected the data, whom have you shared this data with? Get the complete chain articulated, defined. You need both the chains. If you are the source, then where is the destination of the data that you collected? Is within you, or you have shared it upstream, or if it is from downstream that you have got, from where you have got it. Do note you need both of them. If you have received it from someone, do note a change from a user to that source need to also be informed to you, so that if the consent is withdrawn, you have to take action, but provided you know that the consent has been withdrawn. And since you have not collected it, what is your mechanism to know about it? Similarly, when you are the source and you are provided that information to someone up the upstream or to your peers, how are you ensuring a consent withdrawal, as an example, has been informed to all the parties so there is no breach? That's your role and responsibility. You start building internal awareness, key to the success. Train your key employees or employees on privacy aspect of this, especially the DPDP. That's the conversation here. That can start now. You need not have to wait. In phase 2, update your privacy policies and user notices. Make them clearer. Your notices should be clearer, no ambiguity, no hidden agenda. Keep it simple and in multiple languages if it is in India, which is India. So you need to be cognizant of the languages that we are dealing with. If you are dealing with a particular state, with a particular language, you need to have your consent made clear, simpler in that language. So it's understood. Set up consent and grievance redress mechanism. Let the user give and withdraw consent easily. That ownership is with you when they give it or when they want to withdraw it. It shouldn't be a maze wherein I want to unsubscribe but I don't know where the button is, or it is 3 levels or 6 levels below the primary page. That would be taken up as a very serious issue. If the consent takes front page, front button, the withdrawal also should be there. It should be easier. Conduct DPIA, which is the Data Protection Impact Assessment, especially if you are a large or high risk organization. Start the process. Think through how that process should look like. Next is prepare your breach notification mechanism. So if there is a breach, who will respond? How fast? What they get reported? Get your standard operating procedures in place. Complete your review. See that it's in line with what the DPDP expect. If it is not defined, do your best so that when it has been reviewed, there are no red flags. Keep it simple and straightforward so that challenges or suspicions are not there. At part 3, you build a long term privacy culture. How do you do it? You appoint a DPO. That is, of course, if it is required, especially if you are a significant data fiduciary, it needs to be done. If not, you can take a call. Always recommended to have a DPO. Use the privacy enhancing technology, which are tools to automate consent, data tracking, and security. Enable PET. These are available in combinations. It's just about knowing that this is the tool that you are going to use for this specific purpose. Of course, the tool can be used on multiple other rows, but you should be able to automate your consent. That should be straightforward. And also to know where that information that you collected has moved. The whole chain should be visible easily. Run your internal privacy audits regularly. Make auditing mandatory and let the frequency be higher so that initial teething issues are identified early on internally rather than be knowing about it through a breach. Knowing about through a breach is expensive. If you remember the teeth that has been provided to the board, it's 250 crores at max. You don't want to enter that territory at that point of time. The cost of implementing internal controls would be much lower, should be much lower than that. But it's more of a reputation that gets hit bigger than the 250 crores. Stay updated on laws, changes, and board notification. The DPDP framework will evolve for sure. Ensure you have mechanism within your organization which tracks out any changes to this. In simple terms, don't wait for enforcement to start. Start preparing in phases. Begin by understanding your data. Then set up right tools and policies. And finally, embed privacy into your company's culture. Let's now look at a comparison. You can pause the screen and you can go through it, but since the conversation here is DPDP, effective year 2023, not yet enforced though. It applies to digital data of individuals in India or if services are offered to other Indians. Key individual is a data principal, that's you, your data, for your data. The controllers are data fiduciaries or significant data fiduciaries, data controllers. Consent based processing, yes, with notices, must be clear and informed. There are special rules for children, and children definition is under 18. Parental consents are required. Access rights are given to individuals through access, correction, erasure, grievances, and nomination. all of these rights to an individual. Portability is not included at this point of time. The right to freedom to forget is there. It's possible via deletion, but not clearly defined. But deletion is indicated that you can trigger that out. Here we take deletion as forgotten. Does it allow cross-border transfer? Yes, unless restricted. That is referencing the blacklist. If it is not, a country is not in the blacklist, you can transfer. Breach notification, in the draft it is 72 hours, but we expect, I think it could be lower than this. Fines and penalties up to 250 crore rupees. Supervisory authority is Data Protection Board of India. From a record keeping perspective, at this point it is not mandatory. But let's see. This will likely come up. Common sense says so. Legitimate use without consent. Yes. In case of emergency, employment, legal duty, you can use it without consent. But these definitions are clear. And if there is doubt, there is the board that can be approached to for clarification. Data localization is not mandated as it works on a blacklist model. So if it is not blacklisted, it can be moved. In comparison to GDPR, CCPA or PIP-EDA of Canada, this is where DPDP stands. You can pause the screen, you can look at the data, you can get a perspective. So in summary, from a comparison table, key takeaways. Well, DPDP is aligned with global standards on consent, on rights, and on breach handling. But it's still awaiting enforcement. GDPR is the most comprehensive with strong enforcement, portability, and ROPA requirements. CCPA is more business and customer centric with opt out rather than opt in consent. PIP-EDA is principle based with moderate enforcement and more flexibility for businesses. Let's take a sector by sector look at how the DPDP Act 2023 impacts different industries. Because compliance isn't one size fit all. I have compiled a comparative table covering BFSI, IT services, healthcare, hospitality, education, marketing and sales, and the social media industry. So let's break it down. Consent management. Well, consent is the cornerstone of DPDP Act, but its implementation varies. In BFSI, consent must be tightly managed, especially for KYC, biometrics, and financial information. In healthcare, it's even more sensitive. Patients and parents' consent is absolutely critical. For marketing and social media, consent isn't just required, it defines whether your outreach is legal or violation. When it comes to children's data, this is where the act is more stringent or most stringent. Educational institutions and social media platforms are directly in the spotlight here. Under DPDP, profiling or targeting anyone under 18 is strictly restricted. And verifiable parent consent becomes non negotiable. Do note, verifiable. The organization need to have a mechanism where it can prove that the parental consent was indeed from the parent. Next, on the data rights enablement perspective, all sectors must now empower users to access, correct, or delete their data. That means banks, schools, hospitals, hotels, and even digital marketers need process and tools to honor these rights, preferably through user friendly portals. When it comes to breach notification, every sector is now bound to notify the Data Protection Board, and in most cases, the affected individual within 72 hours of discovering a breach. In healthcare, this could be patient's record. In hospitality, it could be passport scan. Or for social media, a profile leak or consent compromise could trigger serious reputational and legal consequence. When it comes to third party or vendor risk perspective, here's where the rubber meets the road. Whether you are a bank outsourcing IT, a school using a learning app, or a marketing team working with an agency, the DPDP Act expects you to own the responsibility for your vendor's privacy posture. Data processing agreements and audits are no longer optional, they are essential. When it comes to grievance redressal, the DPDP Act mandates every organization to have a clear, accessible grievance mechanism. This might look like a chatbot, an email, or an in app feature. And it's especially critical for social platforms, hotels, and edtech apps that serves diverse digital first users. Well, likelihood of being classified as a significant data fiduciaries? Well, lastly, we assess the SDF risk across sectors. It is high for BFSI, IT, healthcare, and social media because of the sheer volume and sensitivity of data they process. For educational and hospitality, it is medium to high, especially if you are running large networks. And for marketing, if you're handling mass personalization and cross platform tracking, the risk goes up fast. So, as you can see, while the principle of the DPDP Act remains universal, the real world implication differs greatly depending on the sectors. Some industry will need to overhaul their tech infrastructure, while others will need to fix their lead generation or outreach tactics. But for all of us, it's a journey towards being more transparent, ethical, and user centric data practice. In the next part, we'll deep dive into each sector one by one. So stay tuned and don't forget to like, share, and subscribe if you are finding this series helpful. Do note this slide we will come again and again on all the modules that we are going to discuss. So, in case you have missed out or you need to have a better context, so when we look at BFSI and IT services and all the other areas, we will refresh this slide again and the context. In summary, the DPDP Act 2023 is India's bold leap into a regulated data future. It aims to empower individuals, formalize fiduciary responsibilities, and position India as a data secure digital economy. While several provisions await clarity through rules and implementation timelines are being finalized, the framework already places India in a close alignment with global data protection standards. As we await full operationalization, organizations and individuals alike must begin preparing today because digital age demands not just connectivity but trust. So in summary, we covered the original agenda of this presentation. With this we will end this part 1 and move towards part 2. I would like to thank you all for the time that you invested. If you believe that this has helped you, or if you think there are someone who can benefit from this video, do share it with them. This is your host, Savit Vittal Salian. Namaskar.